right about 9 o'clock. Today, we're going to go over best practices for dual agency scenarios and post-closing agency relationships and duties. Basically, we're going to talk about some dual agency um, best practices, and then we're going to talk about post-closing complaints, essentially. So, um, you know, how to handle post-closing complaints and not get back into an agency position. We're going to go over on the listing side, the selling side, and actually for leasing as well. That'll be at the end there. So, all right. If you've been in the business a while, I'm sure you are no stranger to post-closing complaints, whether big or small. The deal is closed, either listing, buying, or maybe you leased a property, and your client calls you with some complaints or maybe some needs or something like that. Whether it's right away, maybe it's a month, 2 months, a year. So we're going to go over kind of how to distance yourself a little bit so you don't get back into an agency with that client. And then we're going to start off with some dual agency best practices first, though. So, because this comes up fairly often, yes, it's legal in California. You can be a dual agent. So let's go over a few things here. So who is a dual agent and what fiduciary duties are owed? So an agent becomes a dual agent if they personally represent both parties to a single transaction. An individual agent is also a dual agent if their brokerage represents both sides of a transaction. So it could be two different agents, one representing the buyer, one representing the seller, but if they're from the same brokerage, you would be in a dual agency. When agents from the same brokerage are working with different parties to a single transaction, each agent is considered a dual agent, even if each individual agent communicates and works exclusively with a single party. A dual agent owes equal fiduciary duties to both parties to a transaction. I'm going to reset my desk just a little bit. So, what you'll need forms AD, which is the agency agreement, PRBS, and AC must be in the file and signed by all parties. So if you are in dual agency, whether you are representing both the buyer and seller or the brokerage is representing buyer and seller, those are the forms we need in the file. What is the extent of a dual agent's fiduciary duty? So a real estate agent's fiduciary duty to client requires the highest good faith and undivided service and loyalty. So that is essentially how it's defined. This can be a difficult standard to navigate for dual agents whose service and loyalty are inherently divided between two parties with diverging interests. In the case of Field versus Century 21, the court stated that an agent's fiduciary duty may require investigation and disclosure of unknown material facts that might be reasonably discovered. Unfortunately, there are no clear and easy guidelines for meeting this obligation, as dual agents must often make difficult decisions in balancing clients' interests. You can lessen the likelihood of breaching fiduciary duties by being upfront with their clients about the nature of their duties to each party, and use language in the forms we have available to help explain relationships and duties clearly. I know if you've been in a dual agency scenario, sometimes agents are thinking a lot about the compensation they're going to earn, and they don't keep the interests separate of the buyer and seller. They try and do a lot of verbal negotiating and keeping the deal together because, of course, they're going to make a little extra money on it. And you don't want the money to be the motivator on this. You have to treat it as if you are representing one side only as you're going through. So you put your listing cap on and you talk to the seller, you take that off, you put your buyer's agent cap on, you talk to the buyer. I like to personally let everything play out on paper. I don't really do verbal negotiations in a dual agency. because I want, if the buyer wants to counteroffer the seller and is asking me, what it's going to take to get it done, um, my listing client, my seller, I don't want to cut them short. I want to net them the most amount as well. So I let it put out on paper and say, well, let's put your best offer in a counter offer and send it over. I'm going to present it, then I'm going to talk with them, and we're going to go back and forth. I do the same thing with requests for repairs, especially. I definitely want those to be, to have a paper trail of all my communications and everything, basically how the whole transaction played out. I want a paper trail on it. So I know that I'm at least presenting that I am doing my best in uh, the interest of each client. Um, Here's a snippet from the agency disclosure, Form AD. It talks right here about agent representing both buyer and seller. I mean, this is literally, it's on the first page. You can just go over this scenario right here and really talk about it with the client. Some like it, some don't. They feel uneasy about it. They want, an agent to be separate, and you'll need to, honor that wish. Form PRBS, the possible representation of more than one buyer seller. This is in the listing bundle, so is Form AD. Also goes over dual agency right here. So I like to talk about that when I am dealing with really any client, whether they're first-time buyers or not. Um, when I go to this form, I tell them, some different agency scenarios that may or may not happen, depending on, where we're at. So what form should dual agent provide to clarify the nature of agency relationships with their clients? Both buyer and seller should be provided with a disclosure regarding real estate agency. Relationship with Form AD. The AD provides a description of the different types of agency relationships that can exist in a transaction, including dual agency. Both buyer and seller should also be provided with a confirmation of real estate agency relationships. This is within paragraphs 2B of the RPA or in CAR Form AC, which is preferred to have that separately signed. I prefer to have that in the file. This confirms which types of agency relationships will exist in the specific transaction at hand. If 2B of the RPA is incomplete or completed inaccurately, Form AC may be used. So try and use the AC form. The reason why is because sometimes when you put stuff on a separate form, it brings attention to that form as far as when it's getting signed, because a lot of these things are running through DocuSign and people are just, clicking the little tags on their phone. They don't really read anything when they're going through the initials part, but if they have to sign something, a lot of times it does bring some attention to that particular document. When both the agency disclosure and the agency confirmation are provided in a dual agency situation, the agent's clients are put on notice that the agent represents both sides and owes each side fiduciary duties. The AD provides basic ground rules for dual agency, stating that a dual agent may not, without express consent, disclose to the buyer what the seller would accept lower price, or to the seller that the buyer would pay more. This is where it gets a little tricky and why I like it to play out on paper all the time and counter offers going back and forth. Parties that receive the disclosure in advance have less of a basis for lawsuits alleging breach of fiduciary duty by a dual agent. All right, so we do require the Form AC in the file for dual agency transactions. This is a snippet of the RPA. Obviously, this is what it looks like. If you're representing both sides, you want those boxes checked. Those boxes are not checked. Technically, this is not filled out completely or correctly, and we will need the AC 100% for the file. Statutory duties, a dual agent may not reveal to other party facts relating to the financial position, motivations, bargaining position, or other personal information that impact price in addition to the restrictions already mentioned. So there's statutory duties. One more reason, just let everything play out on paper. In a dual agency transaction, so here's some best practices. Dual agency transaction ensuring fiduciary duty to both parties while maintaining neutrality can be challenging. Here are some best practices to uphold good faith, undivided service, and loyalty. Full disclosure and written consent. Clearly explain to both buyer and seller what dual agency entails, including its limitations, and obtain written consent from both parties before proceeding. That is essentially the AD form, the AC form, and or in the RPA. The PRBS kind of explains it, but the AC form is confirming it, or in the RPA as well. Strict neutrality, avoid advocating for one party or over the other. Looking at you, listing agents, nobody wants to lose the listing. I have found over the years that, in dual agency scenarios, the listing agent who is also representing the buyer in dual agency would, they tend to lean towards the seller because that's the client they don't want to lose more, usually. So be sure you're being as neutral as possible and don't favor one side or the other. Provide facts, not opinions, when discussing offers, counteroffers, and market conditions. Confidentiality and limited representation. Do not disclose either party's confidential motivations, pricing flexibility, or other sensitive information. Ensure both parties understand that as a dual agent, you cannot advise on price negotiations in the same way a single agent would. Fair and honest communication. Provide equal access to information such as market comps, inspection reports, and disclosures. Keep both parties informed throughout the transaction with identical updates. Encourage independent representation. Recommend, but do not require that each party seek legal or financial advice from outside professionals. Use transactional language and documentation. Be meticulous with documentation to avoid misunderstandings. Use neutral, factual language in communications and negotiations. Rely on the language in the forms we are provided. If you haven't really ever read through the forms that we have, a lot of them are set up in a way, especially the agency ones, to really, you can just kind of read them verbatim as you're going through your buyer presentation or your listing presentation on potential scenarios or the scenario that you're in. They really do a pretty decent job of explaining how it works and what everybody's role is in the transaction. So key takeaway, if your broker is a dual agent, then you're a dual agent. Does not matter that there is another agent in the transaction. Dual agency is determined by the brokerage firm. If there is only one brokerage firm, then all agents are dual agents. In other words, if the brokerage firm box is checked for dual agency, then all agent boxes must also be checked for dual agency. On zip form, this will happen automatically. However, if the transaction is being conducted in hard copy, meaning wet signatures, then agents must be careful to fill in the agency confirmation correctly. Otherwise, you risk misrepresenting your agency relationship, a potentially very costly mistake. All right. Do have a link in here for a dual agency training guide that I created as well. It's going to be in the back office too. And we'll post this up with the replay in our Facebook group. All right. Let me see. Q&As, we can go over that. So we'll get into agency relationships and duties after a real estate transaction concludes. Legal, contractual, and practical advice. So listing agents. We'll start with them. When does an agency relationship and accompanying duties begin and end between a real estate listing broker or salesperson and a seller? A written listing agreement creates an agency relationship between the brokerage and the seller. And you can see that in the RLA package, the residential listing package, paragraph 9. An agency also may be created without written agreement, which is rare for agents representing sellers in residential sales transactions, but it can happen. So here's RLA, page 4, section 9, right here, agency relationships. So it talks about it. And even there's multiple opportunities to go over agency and dual agency and all of that. I mean, just in the listing agreement bundle itself, it comes with the advisories and agency in there. You've got the AD, you've got the PRBS, and you also have it in the RLA itself. So there's multiple opportunities for you as an agent to, slow down your presentation a little bit and touch on this so everybody understands and also consents. The agency terminates upon the expiration of its terms or completion of the transaction for which the agreement was created. You can find this in the RLA, paragraphs 9F. And so we're looking at page 5. Here's section F right here. Termination of agency relationship. Seller acknowledges and agrees that the representation duties of and agency relationship with broker terminate at the expiration of this agreement, or if it occurs first, the completion of any transaction specified in this agreement. So it's built into the contract of when agency actually ends. Post-closing complaints. So what actions might a seller's agent take for a seller client after close of escrow? So the seller left personal property behind. We touched on this a couple weeks back with some ways to kind of handle that. Here's, I guess, a quick recap, or we're also going to reference the agreement as well. So if a seller has left personal property behind and pursuant to paragraph 7B of the RPA, a buyer serves on the agent a notice to remove the unwanted items that is addressed to a seller. The agent should forward the notice to the seller if the seller's address is known to the agent. Inform the buyer that the agent does not have the address for the seller. So it's one, those are basically the same, what you would want to do in those scenarios, whether you know or don't know where the seller has moved. And you'll see here 7B of the RPA is talking about condition of property at closing. It says an IV, all debris and personal property not included in the sale shall be removed, closed escrow at time of possession is delivered to the buyer, if not same date. If items are not removed when possession is delivered to buyer, all items shall be deemed abandoned. Buyer, after first delivering to seller, written notice to remove the items within 3 days, may pay to have such items removed or disposed of and may bring legal action as per this agreement to receive reasonable costs from the seller. So that's kind of how you can handle that. There is a demand letter in the, we went over these a couple weeks ago in the car sample letters. If you haven't ever looked at those, if you're in your zip forms library, your lone wolf, whatever you're going to call it, up at the top here, you can change your libraries to the car sample letters right here, and that's where you'll find some of these demands. And so that's how the buyer can essentially move forward with disposing of those items. In either case, the agent may use car sample letter SARDPP to document the seller's agent's actions. Letter SARDPP also acts as a disclaimer of any continuing agency relationship and is not an instruction not to send further documentation to the agent. Oh, sorry, and an instruction not to send further documentation to the agent. So basically, we're saying we're doing this, and we are not in an agency because I'm doing this, and don't send further documentation to the agent. What actions might a seller's agent take for a seller client after escrow if they are A dissatisfied buyer. So again, we're talking about on the listing side, buyer comes back post-closing with some sort of complaint. If a dissatisfied buyer individually or through counsel sends to the agent a demand letter threatening legal action against the seller, the agent should similarly forward the letter to the seller if the seller's contact information is known, or the agent should inform the buyer or attorney that the broker does not have the seller's current address. So basically, you're distancing yourself from that a bit. When forwarding either a personal property request or demand letter, a good practice would be to send the seller a copy of the purchase agreement, advise the seller of the recommendation to seek legal counsel, remind the seller of the obligation to mediate disputes before bringing any legal action, and could even ask the seller how the seller intends to proceed. So we want to, there's a line to walk with this. We don't want to be helping so much, but we also, um, we like to keep the attorneys out of it as much as possible. Most things can be resolved. Pretty much everything probably could be if you have willing parties. So without having to go down the road of seeking attorneys and things like that. If the agent takes any further action, the agent should first confirm in writing the seller's instructions. While negotiating post-closing dispute on behalf of the seller could resolve an issue without any legal action being filed. It could also result in the continuation of the previous agency or the creation of new agency. And depending on the extent of the negotiation and any possible recommendations made by an agent could expose the broker to additional responsibilities for mishandling the negotiation or potentially even practicing law without a license. So contact the broker immediately if you have any post-closing complaints for advice on communications or actions. So we have some demand letters in the car library that can help with this kind of stuff, but we don't want to get heavily involved with shoveling paperwork around and things like that. Now, if they're asking for copies of documents, they can be provided, yes. You can provide them to the seller. The seller can then pass them along as well. Did we have a question come up? Does Rise Realty have a standard or generic post-close of escrow agency termination confirmation letter or agency cancellation letter we can deliver to our clients? We don't, because the agency ends at the close of escrow. Past that, there might be something in the car form library. If you want to check there, we don't have anything like that. I've never had to use one really. All right, on the buyer side, when does agency relationship and accompanying duties begin and end between a real estate broker or salesperson and buyer? A written buyer representation agreement creates an agency relationship between the brokerage and the buyer, and you can find that on the BRBC paragraphs 1A, 1, and 6. An agency also may be created without a written agreement, which is common for agents representing buyers in real estate transactions. The agency terminates upon the expiration of its terms or completion of the transaction for which the agreement was created. Same as on the listing side. What we're looking at right here is BRBC in the grid section. And we are in A1, and you have your term right here. And it says, or completion of a resulting transaction, whichever occurs first. All right, what actions might a buyer's agent take for a buyer after close of escrow? Seller left personal property behind. And I have these here because these are probably the more common ones where the seller left a couch or some things that are unwanted. What do we do with it? Seller's out, they're checked out, they don't want to deal with it anymore. They had no intention of dealing with it probably in the first place. So this is ways that you can handle those scenarios. If the buyer informs the agent that the seller has left personal property behind, the agent can assist the buyer in completing car sample form BDRPP, demand to remove personal property and debris, which the buyer can then send to the applicable address. So we saw it before. It's, send them the notice. They got 3 days to move it. They don't, it can be disposed of. Um, Essentially at a cost that could be passed to the seller, the buyer is going to have to, go to small claims court to receive that, especially if it's a substantial amount of money, um, to, uh, get all of, if there's a lot of items left behind, it could get costly. Um, what actions might a buyer's agent take for a seller client after close of escrow? Seller won't vacate. This is a concern I see from buyers quite often when there is such as like a hoarding situation. I see it as a concern a lot for post-closing occupancy if there's a SIP involved. Sometimes the seller, the buyer has a concern that the seller won't vacate. But let's just say it actually happens, the seller won't vacate. If the seller has remained in the property in violation of the purchase agreement or post-closing occupancy agreement, such as the seller in possession addendum, the SIP, or the RLAS, the buyer's agent may give the buyer a car sample form, letter DSV, demand that seller vacate, to send the seller and attempt to encourage the seller to leave without need for legal action. The agent should also inform the buyer of the need to seek legal counsel to discuss options if the seller continues to remain in possession. So essentially, we can send that demand letter, and then after that, it's, you might want to set them up with an attorney or an eviction company or something like that. What actions might a buyer's agent take for a seller client after close of escrow? Dissatisfied buyer. And this can happen, um, you know, this can easily happen where buyer closes. I see it sometimes on remodeled homes where things have been remodeled and maybe something wasn't put together right inside the walls, it's leaking, and the buyer finds out, that there's, moisture behind the wall or something like that. I see that come up. Homes that have been vacant a long time. This used to be an issue that I would discuss with my clients if they were buying an REO. Because a lot of those REOs have sat vacant for a number of time. And if you're in a drier region, um, what tends to happen is the seals crack inside of the plumbing equipment and mostly in the fixtures and behind the wall and stuff. And I would always warn the buyers about that potential. Because even at the home inspection, they get turned on, they get turned off, and that's it. And then we don't see any leaks. But after repetitiveness, the clients live there a couple weeks, a month or two, or something like that. All of a sudden, everything starts kind of dripping everywhere. And that's because the seals are cracked and all the things because they haven't been turned on in many, many months, potentially even a year, depending on the foreclosure. So, that's something I always warn my clients of when they're buying that type of house. Another thing to keep in mind is whether on the listing or buying side, if you're selling, kind of a fixer home, I see post-closing complaints come up with that as well because whether it's a fixture or maybe just a fixer or like slightly outdated, that the buyer is going to go in there, they're going to gut out the bathroom and start remodeling it. And if the bathroom has been the same way for the past 10, 15, 20, 30 years and it needs updating, more than likely there's something behind the walls. So talking to them about that, I mean, the seller probably has no knowledge of any of that. Any moisture behind the walls or anything like that. Shower surrounds were built differently back in the day, and moisture gets back there. While nothing is leaking, the moisture just over time settles in, especially tile. So I like to talk to people about that kind of stuff during the transaction because what ends up happening is they go to gut out the bathroom and they're like, oh my God, there's mold in the floor or something like that. Well, the seller had no notice, but the buyer should be aware that, when you tear apart a house, things are behind the walls, and that's just kind of how it is. So I like to have some upfront conversations to prevent post-closing complaints instead of just, well, there's a home inspection, everything looks good, see ya, you know. I like to talk to them about some things that they may incur after they start doing their remodel, if I know they're going to be doing a remodel. So let's talk about dissatisfied buyer. I'd be curious what you guys do on those situations too, if you want to throw it in the chat. Um, if you're handling a client that's going to be remodeling our house or anything like that, what do you do for risk management to avoid post-closing complaints? Um, so if the buyer contacts the agent about a broken appliance or system, the agent may suggest the buyer contact the home warranty company that provided the policy purchased in the transaction. I'd say most of our transactions that come through have a home warranty purchased on there. And I'd say well over three-quarters of the transactions, the seller is paying for the home warranty for the buyer. And this is also something I like to lean on for these little nitpicky post-closing things, is the seller's providing this as peace of mind for you in the event there's some things that kind of come up in the first year. So if the buyer contacts the agent about a discovered defect in the property, the agent should advise the buyer of the recommendation to seek legal counsel and remind the buyer the obligation to mediate disputes before filing legal action. So we do want to lean on that. That is a good way to save a lot of money and stress. While negotiating a post-closing dispute on behalf of the buyer could resolve an issue without any legal action being filed, it could also result in the continuation of the previous agency or the creation of a new agency, same as on the listing side. Agent can also expose the agent to additional responsibilities for mishandling the negotiation, potentially even practicing law. So again, same thing as on the listing side. So it is a little bit of a line to walk, and be sure you get me involved on it so that we can navigate that. We have a pretty good track record of getting those settled. Lease listing agent. This one's kind of important for anybody that does leases out there. What tends to happen is if you are representing the tenant or if you find the tenant, the house, a lot of times they keep calling you after the lease is done with complaints or needs and things like that. Same thing on the listing side. You want to make sure that you are presenting to the RPO, the rental property owner, that you are leasing the property. You are not property managing. You are going to get it leased. I have these services that I provide to get the tenant in place. And then after that, we turn it over to you and you are dealing with the tenant directly. Um, so that's how you want to make sure you're handling those lease listings. We do have agents here that do quite a few of them. So when does agency relationship and accompanying duties begin and end between a real estate broker, salesperson, and a RPO, which is rental property owner? A written lease listing agreement creates an agency relation between brokerage and the RPO, and that is section 13, paragraph 1. So RPO, broker shall represent RPO in any resulting transaction except as specified in 3H. The agency terminates upon expiration of its terms or completion of the transaction for which the agreement was created, which would ordinarily be when the RPO and tenant sign a lease or rental agreement. And right here in section F, it talks about the termination of the relationship. And you'll need to check off some of these boxes here if that is when the agency is to terminate. So you'll want to take a look at that. It says by contract, the agency may continue until the tenant takes occupancy. The agent delivers keys to the tenant. The tenant conducts a pre-possession or post-possession walkthrough, or when a move-in inspection is conducted. So you will check the box of when your agency is to end, and make sure that the RPO understands that. So by default, it's going to be entering into a residential or a rental or a lease agreement for the premises. And if checked, choose all that apply. So be sure to read through that section F in the lease listing. And about 10 minutes left. All right. What actions might a lease listing agent take or avoid for a RPO or tenant after lease execution? The agent should not engage in any property management activity. That includes such things as collecting rent. Don't ever do that. Making or arranging repairs, filing paperwork with local rent oversight agencies, holding or returning tenant security deposits. Definitely don't ever do that. All money should go from the tenant to the RPO directly. Don't take checks of any kind. They should always be made out to the RPO as well. Do not have them made out to the company. Paying bills related to the premises, working with RPO or attorneys to give tenant legally mandated notices such as termination of tenancy, change in terms in tenancy, notice to quit. Those things get you into the property management position, which we do not do. And unless checked in paragraph 13F of the lease listing, assisting the tenant with a walkthrough or preparing a move-in inspection or other listed activities. If a tenant contacts the agent about an issue with the premises, the agent should refer the tenant to the RPO. Assisting a tenant after execution of the lease poses legal risk. In that a tenant may be led to believe that the lease listing agent is acting as a representative or agent of the tenant, even if the lease defined the agent as the agent of the RPO exclusively. So this is the agency section, line 41 of the residential lease agreement. And in this example here, we have just Rise Realty on the housing provider's brokerage firm. So we want to make sure that they understand we aren't representing them. If you have that lease listing, you're just putting them in place, and just deflect any questions that come up after that, direct them over to the RPO themselves as they are handling it from there. As agency can be created by one's words and deeds, in addition to the express language of a contract, the agent could also could owe both parties a fiduciary duty from that point forward, which an RPO expecting exclusive representation could argue is a breach of the duty to the RPO. If paragraph 3F of the lease listing is checked, the RPO agrees to compensate the agent if the tenant purchases a property during the term or any extension thereof. This gets overlooked quite often, and actually this happens quite often. So you could also check this box here, section F, compensation of subsequent sale. So you put the tenant in, and tenant decides they want to buy it from direct from the owner. There could be a built-in fee for you there. All right, to wrap up, if the broker is informed of the purchase in advance by either RPO or tenant, a court could very well conclude that in exchange for compensation promised to be paid by the RPO, the agent has an obligation to act in an agency capacity for the sales transaction. This would entail all the usual responsibilities of a sales agent, such as helping with the preparation of a purchase agreement and contacting escrow. The purchase agreement should identify whether the agent is acting as an exclusive agent for the RPO/seller or dual agent representing both RPO/seller and tenant/buyer. Regardless of the circumstances of any of these scenarios, give me a call if you're having any sort of snag or any post-closing complaints or anything like that, so that we can work on getting those resolved quickly and efficiently. Like I said, we have a really good track record with post-closing complaints and just getting them resolved. without it costing too much money for anybody. So just let us know if you see something headed down that way, you get some sort of demand, you get a notice, anything like that. Give me a call so we can talk through the scenario and we kind of handle it from there. So hopefully that was informative for you. I know these little things come up, these little loose ends, if you want to call them that, these post-closing complaints, they are annoying. We do need to handle them the best as possible so they don't get out of hand and turn into a lawsuit. But like I said, it is a fine line with creating new agency or continuing agency, and also just handling it in a way where we don't get into that agency scenario or practice law. We don't want to do that either. So hopefully that was informative for you. We'll be back next week and hope everybody has a great week. If you have a property that you would like to pitch to the team, upcoming listing, slow selling listing, office exclusive soon. Soon is going to be a thing. Just let us know, either email me or Alicia or Roxanne or anybody, and let us know that you want to present that. Have a picture ready or a couple pictures ready, and we'll let you go on in the beginning of the meeting, and you could do your property pitch. You have about a minute or so to just kind of do your elevator pitch, as you will, for your listing. So other than that, if you have any questions on anything, I'm always around, and I hope you have a great week. We'll talk to you soon.